Yesterday, right after we got off the air, our next guest got some news that probably made his day and at least either made June or made July. Josh Hawley is with us, an attorney. Josh, welcome back to the Big 550 KTRS here in St. Louis.
It's great to be with you.
You got it. First of all, you're an associate professor at Missouri. Is that correct?
That's right.
Do you think maybe you should be a full-time producer after winning a Supreme Court case?
I'll mention that to my dean. I think that's a great argument.
All right. Josh, you've been on the show before, and you were part of the law team that now successfully argued the Hobby Lobby case in front of the Supreme Court. How did you find out? Did you find out like the rest of us?
Well, I found out, like I'm sure many folks did, by watching what's called a live blog. The Supreme Court's an old-fashioned place. I worked there a number of years ago as a clerk to Chief Justice Roberts, and it always struck me as interesting. There are no cameras allowed in the courtroom, and so the way you have to find out about these opinions are either you have to guess correctly what day your decision is going to come down and fly to Washington and wait in line and try to get a seat in the courtroom, which almost nobody can do, or you have to wait for the Supreme Court press people to distribute the opinions hard copy by hand to reporters who then blog about it or go on the air about it. So, it's really getting these decisions. It's really old-fashioned. It's like watching a telegraph wire or something. So you sit there and you wait for the reporters who are physically present to blog about it, and that's how I found out yesterday.
That's they would at least, considering you were one of the ones involved in the case, they would have given you at least a little bit of a heads up, but I guess not.
It's a tradition, McGraw. The suspense is all part of the fun.
I guess so. So the court, and the last time you were on, you were brilliant, and certainly understand why you argued the case, and the argument you made, I guess, won the day. So quickly, what's the argument? What's the reason they agreed with you and your side? And is there anything in their decision that they disagreed with you on, but then ultimately the ultimate argument won to you? So, in other words, what's the argument that carried the day that you told them?
The argument's twofold. It is that, first of all, under this important law called the Religious Freedom Restoration Act that President Clinton actually proposed and signed into law back in 1993, under that law, business people whose religious faith is substantially burdened by a federal government regulation, they have the right to come into court and to make the government show that the burden on their faith is justified by a compelling government interest. So that was argument number one. The government had argued that when you go into for-profit business, when you incorporate your business, you give up the right to raise any religious liberty claims. You give up religious liberty rights. And I would just say, note, McGraw, that of 9 justices, only 2 justices agreed with the government's argument on that point. So that was a pretty decisive loss for the administration. That's point number one. Point number two is we argued that the government in this case can't show that it has a compelling interest that it has pursued in the proper way in forcing conscientious religious objectors like the Greens who own Hobby Lobby from funding these 4 forms of contraception that induce the equivalent of an abortion. That's what this case is about, not contraception in general, but just 4 forms. And we said, the government can't show that it has a compelling interest here. Why? Well, because among other things, the government has a lot of ways to make these 4 drugs and devices available to women for free without forcing religious objectors to pay for it. And that is exactly what the Supreme Court said in agreement with us yesterday. They said, the government can deliver these 4 forms of these 4 drugs and devices in lots of different ways. It doesn't have to force people of faith to violate their religious convictions.
The argument against Josh Hawley and the argument since this decision came down, the other side is saying, okay, great. And as you mentioned, it's only these 3 or 4 types of contraception that Hobby Lobby has an issue with. But I'm a religious man. I'm Catholic. I'm against the pill. What's to say I can say to my employees, I'm not paying for the pill?
Well, If a Catholic business owner, another business owner, has a religious objection to all contraception, then those cases will be made. There's some of those cases out there, and the rule of law, McGraw, is the same. So what has to happen is the courts have to ask, is that a sincere belief on your part? Is the government forcing you to violate it? And then they have to say, well, does the government have a compelling interest in forcing you to violate it? And in the case of contraception, the thing is that the contraception is so widely available. And again, the government actually has means of making all 20 forms of contraception that are legally approved for sale in this country, making those available to women for free if the government so chooses. It's pretty hard to show that the only way to make contraception available to women is to force people who have religious objections to pay for it. So, the tougher questions are questions like, well, what if you get somebody who is opposed to blood transfusions as part of their religious faith, or opposed to vaccines as part of and then doesn't want to pay for those things for their employees. And, if those kind of questions came up in the future, I think that you'd find that the government probably wins those cases. Why? Because the government, in most cases, is going to be able to show that it has a compelling interest, particularly in life-saving medical procedures. So yesterday's decision was, I think, a modest decision. It was a careful decision. It was a big win for religious liberty based on the principle that it announces. But it is not a sort of sweeping, startling decision in any way.
Let's say I have a religious belief that I'm against homosexuals, and I have a cafe and I have a diner, and two homosexuals want to be served breakfast, and I say, I'm sorry, that goes against my religious beliefs. Do I have that right not to serve them breakfast?
Well, the Religious Freedom Restoration Act, which is the law we've been talking about that the case was decided under, it's been on the books since 1993, and I am not aware of a single case that has ever been brought making that claim that you just made. So I think it's pretty unlikely that those kinds of claims even get brought. I mean, like I said, I haven't in 21 years, I guess it's been, there hasn't been a single case making that claim. The other thing that I would say, though, McGraw, is that what the Hobby Lobby case is about, there was no discrimination of any kind alleged in this case. So the Supreme Court didn't address that at all. And I would think, finally, last thing I would say is, I would think that it would be a pretty tough claim for a business owner to say that I just don't want to serve particular kinds of people just in general. And just in general, I just am not going to serve particular kinds of people. That's an awfully sweeping kind of claim. So again, the court did not address that issue yesterday. Those kinds of claims have not been brought, and I'd be surprised to see a claim like that one get brought in the future.
Right, Josh, and you are, I have to tell you, I've been doing talk radio for 20-plus years now, and you clearly are one of the most brilliant guests I've ever had on, because the way you break it down, the way you explain it, it's really, really interesting. So I want to thank you for that, and I want to thank you for your time today and in the past, and hopefully in the future when stuff comes on, we can have you on more.
Always a pleasure. Thank you.
You got it. But the argument is, let's go back to the gays for a second. You said that no one's ever brought up that charge. Well, there are states that blanketly say we don't want gays to marry because of my religious beliefs. And so whole states have decided that because of my religious beliefs, gays shouldn't marry. So the question is, if Hobby Lobby has a right to say, hey, wait a minute, our religious beliefs should be upheld here, what about the religious beliefs of somebody else who says, I don't want to hire gays, I don't want to serve gays? It seems like it's a similar argument.
Well, it's a very different thing. I think the marriage laws of various states, including the state of Missouri, that most states, in fact, that define marriage to be between one man and one woman, as has been traditional for many centuries. That's different. Whatever you think about that, by the way, McGraw, that is a different kind of claim than a business owner saying, I don't want to serve gay people who walk into my restaurant, or I don't want to serve gay people who come to my hotel. Those two things are really different, and it's the second thing where you say, well, the hotel owner, I'm gonna ask who my guests are. I don't want Muslims to stay here. I don't want gay people to stay here. That kind of thing, again, it's that sort of claim that we have never seen made under the Religious Freedom Restoration Act. And frankly, I think courts would be pretty darn skeptical of a claim that is that broad. I mean, that is really sweeping, really, really sweeping. And so, yesterday's ruling, I think, doesn't give a whole lot of support for people who want to just in general not have any association with other folks on the basis of their faith or their sexual orientation or what have you.
Yeah. The side that lost is screaming, the sky is falling. The side that won, Josh, your side is saying, hey, look, this is a very narrow ruling, and this is not going to open the floodgates. This is a very narrow, very simple, very nuanced position for companies who want to maintain their religious beliefs. But yet this closely held company line affects 90% of businesses out there are defined as closely held companies. So do you see more companies coming out and saying, hey, we're not going to cover contraception for women because of this?
Well, I think what makes the ruling narrow and modest, McGraw, is the standard that the court used. The standard that you have to show that you have a sincere religious belief, which, by the way, is going to be pretty hard for most corporations and businesses to do, because most corporations and businesses, especially publicly traded corporations, they're not organized the way Hobby Lobby was. I mean, the Green family who own Hobby Lobby, they've been building in a religious and socially conscious mission into their company from the very beginning. Well, that's just not true of most publicly traded corporations, which is fine.
Right.
But it means that most of those kind of corporations, they're not even going to be able to get over the first hurdle and show that they have a sincere religious belief. But then the other thing is that, again, just because you have a sincere religious belief doesn't mean you win. The government, if the government can show they have a compelling interest in making the burden stick to you, well, then they can do that. They can go ahead and impose the burden. So I think what makes this case modest and what makes it a great win for religious liberty that everybody can celebrate without fear of what may happen down the road is that this neutral standard that the court used is a good one. It's one that served us well for 21 years, and I think that the crazy hypotheticals that you hear coming from some opponents of this decision, I just don't think that those hypotheticals will pass muster under this standard that the Supreme Court's using.
Josh, if the company weren't Christian and it were Muslim and it had an issue with birth controls, would the Christian community be as thrilled upholding the Muslim right to their religious freedoms as they are with the Christian right?
Well, I would sure hope so, and I can only speak for myself and the Beckett Fund for Religious Liberty, who litigated this case, and where I am counsel. And I tell you what, McGraw, we have defended Muslims, we have defended Hindus, we have defended Jewish folks. So we've defended the religious liberty of all, and everybody is equally burdened by this mandate that the Obama administration has attempted to impose. But let me give you another example. At oral argument a couple of months ago, Justice Breyer asked the government, what about a kosher butcher? So a Jewish butcher who is running his business or according to Jewish food laws, what if a city or a state passed a law that banned the kosher slaughter of animals, which, by the way, some countries in Europe have now done, so it's not really a hypothetical question. And the government's response to that was, well, that would just be too bad for the butcher. The butcher would not be able to make a free exercise claim or claim any protection under the law. Well, now that's a pretty extreme position, and it's that position that the Supreme Court rejected yesterday. They said, no, you can come in, just because you start a business doesn't mean that you give up your free exercise rights. And that's true whether you're Jewish or Muslim or Christian or anything else.
It's a really, really interesting conversation. Josh Hawley was in the room. He lobbied on behalf of Hobby Lobby in the Supreme Court case. Josh, what has your day, what has your world been like since this decision came down?
Well, I tell you, it's been a crazy 24 hours. We've been celebrating and trying to explain the decision to people all around the country who are interested. And I just hope, McGraw, I think, again, that this is a decision that everybody ought to be able to celebrate. And here's why. We have a great tradition in this country of allowing people of every religious faith and no religious faith to live out their beliefs in public peacefully, so long as they don't hurt other people. That is one of the greatest things about our American tradition. And this case is really just a reaffirmation of that. The Supreme Court emphasized over and over in its opinion that for women who want to get these 4 forms of contraception that are at issue in this case, they will have access to those drugs and devices. This case is not about denying anybody access to anything. The case is just about whether we force people of faith who have strong faith convictions, whether we force them to violate those convictions as part of doing business in America. So this just reaffirmed our long-standing constitutional tradition that, again, is one of the proudest things that we share as Americans.
Josh Hawley, associate professor at the University of Missouri. They should drop that associate. Man, anytime you successfully defend a case in front of the highest court in the land, you should get a little bump up somewhere along the line.
Well, I can't. I won't disagree with you about that.
Josh Hawley, thank you very much for your time on a very busy couple days. Have a good 4th of July.
Thank you. You too, McGraw.
You got it. Josh Hawley with us, who was in the room. He helped argue the case for Hobby Lobby. And that's a really, really, really smart guy and a really, really